Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. On Friday, as you probably all saw, the state's case against Alec Baldwin was dismissed. And ordinarily, that would be the end of the deal for Alec Baldwin. He could consider himself a free man. But he may, in fact, only be able to consider himself a free man temporarily because the state in New Mexico has a right to appeal from the motion to dismiss. In fact, let's take a look at the actual language of the statute as it relates to an appeal. This is from the Chapter 39, Article 3, Section 3, Appeals from District Court in Criminal Cases. Within 30 days from a decision, judgment, or order dismissing a complaint, indictment, or information as to any one or more counts, the state can appeal to the Court of Appeals or the Supreme Court. And it says that no appeal shall be taken by the state when the double jeopardy clause of the United States Constitution or the Constitution of the state of New Mexico prohibits further prosecution. Now, in addition to this part about they could appeal from the motion to dismiss, you'll notice down there it says you can't appeal if jeopardy has already occurred. But the difference in New Mexico is that they distinguish between the start of jeopardy, which in many states means that once the trial has started, there's no going back, and the conclusion of jeopardy, which in New Mexico they consider to be the termination of the case. So the normal termination of the case, not a motion to dismiss. And so here is what the most recent case dealing with that issue deals with, and it's State versus Roybal. And in that case, the gentleman was charged with a drug offense, and he was indicted in the wrong county. And he raised the defense of an improper venue in the trial court, and the trial judge withheld ruling on it until the end of trial. And then at the end of trial, after all the evidence and all the argument had come in, he dismissed the case. So the state appealed. And of course, the defendant said, hey, time out. Wait a minute here. Deputy already attached. And they said, yes. Well, we'll let them tell you what they said. Defendant argues that the state had no right to appeal because the trial court dismissed the charges with prejudice after defendant had already been placed in jeopardy. Generally, the state may appeal from an order dismissing an indictment. However, no appeal is allowed when the double jeopardy clause prohibits further prosecution of the defendant. We hold the double jeopardy clause does not bar a state's appeal because although the jeopardy attached once the jury was impaneled and sworn, jeopardy never terminated. And then they cite a Supreme Court case on point, stating that once a defendant is placed in jeopardy for an offense and jeopardy terminates with respect to that offense, the defendant may neither be tried nor punished a second time for the same offense. As discussed above, the trial court dismissed the charges upon a finding the state failed to prove venue in Santa Fe County. Venue refers to county or counties where a crime was committed. Venue is not an element of the crime charged and does not go to the guilt or innocence of the defendant. Now, obviously, in this situation, what we have is a situation where the state has failed to turn over evidence. It's a potential Brady violation, but not really. And it doesn't go to the elements of the offense. It's not something that relates to any of the charged crime. And so, applying the rationale from State versus Roybal, obviously there should be no double jeopardy problem here in this case. So I am not critical of the judge for protecting the defendant's rights, because that's clearly her job. But I am critical of what I believe to be an emotional decision, a decision made not on the basis of the logic in the law, but rather on emotional factors. I'll put it that way. You know, perceptions create images, and images create opinions, and there is already in this country a general belief that if you have money, you can skate by on anything. And there is some evidence of that, quite frankly, if you look at things like the O.J. Simpson case. And then there's this case. It will be Exhibit A in that discussion going forward. Now, Baldwin here hired Quinn Emanuel. I mean, those guys have lawyers that charge $1,000 an hour. I don't know if These guys charged $1,000 an hour, but they certainly could have. They're New York lawyers, and that's a normal legal fee in New York. He brings in these hitters from New York City, and they staff that case like it was the D-Day invasion. And they turn up one little thing of evidence that wasn't turned over, and they make a mountain out of what is a molehill. Why do I say that? Well, what were the material issues in the trial? First, did Baldwin pull the trigger? Well, ammunition from another film that was turned over because it might be related, even though it had a different look and a different chemical composition, that's not related to whether he pulled the trigger. Did Baldwin point the gun at Helena Hutchins? Again, that's not related to that. There's no way that the rounds in that gun or where the rounds came from has any impact on whether he pointed the gun at Helena Hutchins. Did Baldwin violate all the rules of gun safety? Again, it's not related to that. And the bottom line issue, was Baldwin criminally culpable for negligence? It's not related to that either, because it deals with a collateral matter, where the ammunition came from. Unless Baldwin brought the ammunition to the set, in which case I suppose it might very well be relevant, the fact that the ammunition was there is due to the acts of third persons that are not charged, and there's absolutely no way that this matters. So remember, these rounds were from the training session for cowboys who were going to appear in the movie 1883. Went down to Texas, and these guys did some shooting. They used live bullets, and of course they used live bullets to teach people how the recoil works, right? So they bring these back, and somebody gets to thinking, well, you know, these could be very similar to the rounds that were in the Rust set. And so the guy turns them over to the state, and the crime scene tech put them in a different case. She says she did that in consultation with the prosecutor, and I don't have any reason to disbelieve that. My issue is, even if she'd flushed them down the toilet, the bottom line is they are not relevant to any of the issues in the case. Does the provenance of the bullets used have any bearing on negligence? Well, Baldwin wasn't responsible for procuring the blanks. He wasn't responsible for procuring the guns. He wasn't responsible for anything except hiring the armorer, which obviously he did a pretty bad job of. He wasn't responsible for loading the firearm. The firearm should not even have been loaded when they were doing this blocking thing. That alone is negligence. He was arguably responsible for checking the firearm to see what kind of rounds were in it, but since he didn't check, where the rounds came from doesn't matter, and it's not material. It's not material to a fact in dispute. It might have been in the Hannah Gutierrez Reed case, but it's not in this case. And in fact, I think you may see some fallout from the Hannah Gutierrez Reed case here, because apparently they didn't have this information either. So what we're talking about is something that, had Baldwin intended to introduce it into evidence in the trial, it would have been irrelevant and immaterial. Why then would that constitute either a Brady violation or a rule violation if it was not directly related to the case? If anything, it is tangentially related, and you have to look pretty hard to find that connection. So let's do a hypothetical here. Let's suppose you had a diabetic who knows he's prone to hypoglycemia. I'm diabetic, I have a pump, I know if I give myself too much insulin, my blood sugar can fall, and I can develop hypoglycemia. And I know if it goes too far, I start having visual disturbances, and if I don't correct it pretty quick, I faceplant. So let's suppose our hypothetical person takes his insulin because he's getting ready to eat some French fries with his lunch, and he looks down and he realizes, holy cats, I'm out of ketchup. He hops in the car, drives down to the Quickie Mart, and on the way back, because he took his insulin before he left, and he didn't eat anything, he blacks out and kills an oncoming driver. Now, what things would be relevant in that case? Well, the amount of insulin he took, that'd be relevant. The type of insulin, was it fast-acting or slow-acting? If it was fast-acting, that'd be relevant because it works quickly. Fast-acting does sort of suggest that. Did he have a history of prior episodes? That could be relevant. What was his blood sugar on admission to the ER? All of those are relevant facts, things that the jury would need to know. All of those are relevant, so they would all be given to admission. Now let's say that when they tow the car to the impound lot, the CSI going through it is looking essentially for alcohol and intoxicants because the guy passed out at the wheel. She sees the ketchup bottle, but she doesn't retrieve it. Later on, he talks about having gone to get ketchup, and she remembers this ketchup bottle, and she brings it to the prosecutor and says, hey, this is the ketchup the guy went to get. Again, it's not relevant to the amount of insulin, type of insulin, history of prior episodes, or blood sugar on admission. It's just there to explain why he went to the Quickie Mart. So the CSI doesn't see any evidentiary value in the bottle of ketchup, and as a result, doesn't turn it over when asked for all of the evidence. Should the case be dismissed? Of course not, because the evidence, such as it is not material to a fact in the case and could never be exculpatory. That's where we are here. The fact that there are rounds there from another movie brought there by a third party unrelated to the case, someone who's not charged, someone who didn't really have any input into this at all, Mr. Teague, none of that is exculpatory in any way with regard to Baldwin, because Baldwin's negligence isn't in loading the gun, isn't in discerning whether or not there are blank rounds or dummy rounds in the chamber. No. He is charged with pointing the weapon at a person and pulling the trigger. And that's very similar to what we're at here. I want to go over something else that I think is really important here. And that is this. If you compare the judge's demeanor in the Hannah Gutierrez-Reed case and the judge's demeanor in the Baldwin case, you see two different things. First of all, in the Hannah Gutierrez-Reed case, the defense got almost no traction on any of its objections. She summarily overruled them. And maybe that was the right decision, maybe it wasn't, but she knows that evidentiary decisions are generally discretionary. Because it's discretionary, she knows she's unlikely to be reversed on appeal on any of those. And I think when you look at how she reacted when she sentenced Gutierrez-Reed, I think it's pretty clear she didn't like the woman. And she was certainly upset by the calls, and I understand that. It's okay to be upset. It's okay for that to figure in some way to your sentencing decision. But it looked punitive and it looked personal, in my opinion. Again, that's just my opinion. That's just what I'm reading in from having watched the video of that particular interaction. Given that, now let's look at what happened in Baldwin's case. Mr. Spiro would get up, smile at the judge, act like butter wouldn't melt in his mouth, and he would make his objections, and over and over and over again, they're sustained. Now again, they're discretionary decisions. The judge had every right to make them. She made them what she made them, and that's the way it is. But if you look at the difference in affect and demeanor between the two cases, you begin to wonder if the judge is somehow starstruck. That's what I wondered. Now, how that could be with Alec Baldwin, I don't have any idea, because he sat at the counsel table with those birth control glasses on, and I thought to myself, how does a guy who makes that kind of money and lives in Hollywood not be able to afford good glasses that make him look like something other than Mr. Magoo? But apparently he couldn't. In spite of that, I do think the judge had a great deal of sympathy for Mr. Baldwin. I think because she convicted Hannah Gutierrez-Reed, she maybe felt this was an unfair application of the law. I don't know. But the analysis that she did in this case on the motion to dismiss was flawed, because she never considered the objections raised by the prosecutor that none of those rounds figured into anything that happened in the case. None of them. And even if they had been the source of the rounds that killed Helena Hutchins, Baldwin had nothing to do with that, and it didn't matter. Now, while you could throw a little shade on the quality of the investigation by pointing out that those rounds maybe should have been looked at more closely or something. The bottom line is none of that information was relevant, and the judge made an emotional decision because she was irate at the prosecutor and not a logical legal decision. And I think she's going to come to regret it, because if the state appeals, and I hope to heaven that they do, then I think the case is going to come back because she made a huge mistake here. I saw last night that the prosecutor in this case, Kara Morrissey, had some statements to make. She said she didn't agree with the judge's decision, but she respected it, which leads me to believe she's probably not going to file an appeal. And I also saw an interview with Mr. Bowles, who suggested that he's going to file a motion to overturn Hannah Gutierrez-Reed's conviction on the basis of prosecutorial misconduct. And I hope it isn't lost on anybody that this is not an elected prosecutor, that she was appointed to do this job, that she's primarily a defense attorney, and that she would know the rules. And I don't think, looking at her, I don't think she tried to cheat. I think she may have been undone by careless people. I don't know. But I do think she deserves a thank you from the citizens of New Mexico for trying to do the right thing, or hopefully trying to do the right thing. So that's just my opinion. You may have a different opinion. If you do, drop them in the comments down below. Maybe you can convince me. I don't know. I've had things where I've said things and people have dropped comments and I said, okay, man, that makes some sense. Maybe you're right. I don't know what really happened on that set, and I don't know why the judge made this decision. I don't think she made a good decision, right? But again, I'm in the role of commentator here, and I'm offering my opinion. It isn't fact, and I certainly don't want anyone to think that I'm accusing her of any, incompetency or corrupt behavior, because I'm not. I think she just got overwrought with emotion and made the wrong call here. At the end of the day, that's what I believe. So if you have comments, drop them in the comments down below, or you can email me at the address above. Like, share, subscribe, all that stuff we ask you to do here on YouTube. If you have the opportunity today, take a moment or two out of your day. Do something nice for someone. Maybe send somebody a get well card that you know who's under the weather. Maybe you just go visit somebody in the hospital that you know is in there. Lots of things we can do to make people have a better day. And of course, anybody that you make have a better day, that helps you too. It makes the world a better place as well. Thank you for watching. Come on back tomorrow after you do something nice for somebody. Catch me at the beach, and we'll have fun together. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.